Eggshell skull rule, aka eggshell rule, thin skull rule, eggshell plaintiff, says that defendants who commit a tort assume the risk that a plaintiff could have a predisposing condition or pre-existing injury. Courts hold defendants liable for the resulting injuries of the tort, even if it is due to the plaintiff's prior condition or eggshell skull. For our example, we will use the eggshell skull itself to explain where the doctrine came from. If plaintiff is a person who happens to have a soft skull, compared to other humans, and a defendant commits a tort against plaintiff, such as slapping him in the back of the head as a prank, which results in plaintiff having fractured skull, he will be held liable for the full extent of the injuries, even though defendant may have reasonably thought a slap to the head was not something that was going to severely injure plaintiff or certainly not break his skull. Exacerbation of a prior condition is a phrase used often in conjunction with eggshell plaintiff. Emotional distress can usually be discerned by evidence of anxiety, depression, loss of ability to complete tasks, and physical illness. Generally, legal torts claims for emotional distress require that defendant has done an intentional or negligent act which resulted in mental anguish and other physical harms to plaintiff. Enjoin is a legal prescription or prohibition through injunction, a court order to do/not do something. Estoppel is a tenet which mostly says that a person cannot claim something opposite of a previous claim, just because it becomes more beneficial to hold the opposite position or behave the opposite way. Do not let this word confuse you, it literally just means stop. A party or potential party is stopped from doing something, for some reason. Estoppel comes up in just about every area of law. Ex parte, a hearing or meeting with a judge in which only one party is represented or at least one party is not represented. Execution, to carry out or make effective. In torts, it can refer to execution of judgment. Expert witness, a person with no personal knowledge of a civil or criminal case who has specialized skills, training, knowledge, experience or education in a particular subject area whose opinion testimony is permitted by the court because it may be of help to a finder of fact in determining the reliability of a fact at issue. F. Failure to warn is disregarding one's duty to warn others of a risk or danger. Failure to warn is a strict liability claim which does not require proof of negligence. False imprisonment, intentional civil tort. The knowing wrongful restriction of a person in a bounded area with no reasonable means of escape and without the lawful right, legal authority or justification. False light, invasion of privacy tort. Defendant gives a misleading or untrue impression to the public regarding plaintiff. Similar to defamation. Federal Torts Claim Act, FTCA, the legislation which permits plaintiffs to bring claims against the federal government or government actor, acting on behalf of the government, in such cases where a similarly positioned private person could be sued. As opposed to sovereign immunity. Food poisoning, strict liability tort. Food purveyor may be held strictly liable for damages caused by tainted food. Foreseeable, the bench/juror applies a reasonable person standard to determine whether defendant should have expected the circumstance which led to a harm. Usual legal term, reasonable foreseeability. Fraud, defendant's knowing and/or reckless false misrepresentation or concealment of a material fact intended to induce the plaintiff to act to their own detriment. Fright, synonymous with reasonable apprehension. Frivolous, having no legal merit or basis. Example: a frivolous claim is a claim which serves no purpose or brings an insincere claim. Frolic, employee's significant deviation, usually for personal reasons, from employer's work assignments. A frolicking employee's tortious acts fall outside the scope of employment and therefore are not subject to respondeat superior liability. An employer is not considered vicariously liable for an employee's conduct during a frolic, as opposed to a mere detour, which is a minor deviation from work assignments.